on the dais and the members of the audience, a very good morning to all present here. Ralph Waldo Emerson says that there is no better way to exercise imagination than the study of law. As a new set of students begin their journey in legal education, here at DME, I, Naisa Sharma, final year law student, DME Law School, welcome you all to the orientation program of batch 2024 to 29 of DME Law School, Noida. Today, we have with us Honorable Mr. Justice Naveen Sinha Sir, former Judge, Supreme Court of India, as the chief guest for the event. We welcome you, sir, and are honored that you could join us here today. I would also like to welcome Honorable Mr. Justice Bhagat Singh Sir, Director General, DME, and former Judge, Allahabad High Court, Professor Dr. Ravikant Swami Sir, Director DME, and Professor Dr. Rajinder Kaur Randhawa Ma'am, Head Law School, to the event. To begin the ceremony, let's invoke Goddess Saraswati's blessings by lighting the lamp of knowledge and wisdom. I request the dignitaries to light the auspicious lamp and embark on today's proceedings. As new members stepping into our DME family, I am sure that you would be curious to learn a little more about our institution. Let us look at some glimpses of the DME Law School through its activities conducted in the past years. I request the IT management team to kindly play the video montage for us. I request our Director General, Honorable Mr. Justice Bhavar Singh Sir, to welcome our Chief Guest, Honorable Mr. Justice Naveen Sinha Sir, with a planter. I now request Director DME, Dr. Ravikant Swami Sir, to please address the audience.
My dear students and faculty members, another great day, another milestone in the history of DME. Two great personalities from the Supreme Court of India on the dais. The personalities will be introduced by the anchor, but I'll tell you about their contribution to this nation to which we belong. Justice Naveen Sinha has contributed through his judgments. So sir, Google says there are 9 judgments which your pen has written, which have shaped this country, which will have a long-lasting effect. So students, you know that the federal system is always challenged. And when GST came, this federal system was obviously challenged, because if the center is collecting all the taxes and then redistributing, then it's too much of centralization. So it was Justice Naveen Sinha's pen which said that alcohol is something which is a huge revenue earner. So that should be with the states. And that is why 2 things are out of the purview of GST. One is fuel, another is alcohol, and both are huge revenue earners for the states. So, thank you sir for helping this country maintaining the federal system. Another landmark judgment which sir ordered was regarding the insolvency and bankruptcy law. Yes, that is a law which is very much required for a nation which is embarking on a journey of economic growth. So, sir upheld the constitutional legality of the insolvency and bankruptcy law. Other than that, there are many more judgments, but I would stop here by telling two important judgments which will be there for centuries to come. We also have with us Justice Bhavar Singh sir. So, sir's contribution. Sinha sir, you did your law from Campus Law Center. And if you remember, there was a dispute pertaining to that which was solved by Justice Bhavar Singh. So DU had 3 different law schools, and Bar Council of India was in a quandary, and therefore they invited Justice Bhavar Singh to sort out the dispute, and eventually all those 3 were brought into one campus, and that is why we have Campus Law Center 1, 2 and 3. So that was again Justice Bhavar Singh's contribution. Other than that, the contribution to the Ram Mandir judgment by Justice Bhavar Singh, all of us are aware that the magnetic survey which was ordered by a 3-member bench of Allahabad High Court, sir was part of that, and it is that magnetic survey which did away with all the emotional element and things came to a scientific conclusion. So thank you sir for your contribution to this nation. Coming to the orientation, students, it's a 5-year journey you are embarking upon, and we should tell you, and you should also know what is expected from you. So, of course, we don't expect you to touch the sky and all that. All those things are popular, but we can't speak in that language. So we expect a parameter. We expect 3 things from you. We expect you to enhance your knowledge, your skills, and above all, your attitude. So how would you do that? How would you enhance your knowledge? Well, knowledge you will be getting from your teachers, from the classroom, from the library, and of course from YouTube with great channels like the one run by Dr. Faizan Mustafa. So all those things, of course, YouTube also contributes to our knowledge. Wikipedia also does that. So all those things will be contributing to your knowledge, but you have to see that every day when you go out of the gate of this college, you should ask yourself, have I enhanced my knowledge? So that is the first thing. Second is the skill part. Yes, for an advocate, mooting is a great skill. Without mooting, I think for an advocate, a key skill is how to make summary of a summary of a summary. Right? So every time in the court, you would be asked a question by the judge, how much time you are going to take. So that is why you need to learn how to make a summary of a summary of a summary. A 100-page submission has to be summarized in 3 to 4 minutes before an honorable judge. So the skills of mooting, then we have PSDAs for which your teachers will be telling you the topics. So all those are skill enhancement activities. We also have a set of visits. We take you to various places where you learn how law is made and how law is broken. So, and the third part is attitude, which in the traditional manner is defined a glass half full, half vacant. But I think my definition of attitude would be that if your mother is hospitalized on a day and on that day you have an important hearing, you have to attend that hearing. That is my definition of an attitude which you must inculcate. So we welcome you to this 5-year journey and the journey with the little changed laws of this country. Thank you.
Thank you, sir, for your inspirational words. No institution can run without the presence of a good leader, and we are grateful to have our Director General, Honorable Mr. Justice Bhavar Singh sir with us. His Lordship was appointed in UP Judicial Services in 1970 and was promoted to Higher Judicial Services in 1979. He then presided over a special court of CBI, Dehradun, and was elevated to Registrar, Allahabad High Court in 1992, where he worked for about 3 years. Sir then graced the office of Registrar General, Supreme Court of India, and was elevated to Permanent Judge of Allahabad High Court in 1999 and held office up to 2007. His Lordship was then appointed for 5 years as President, UP State Consumer Commission. Thereafter, Sir adorned the office of Chairman, Judicial Training and Research Institute, UP, from 2012 to 2014 and joined the ME as Professor and Director General from 1st July 2014. I request Sir to please address the audience.
My Lord, Honorable Mr. Justice Naveen Sinha, former Justice Supreme Court of India, Dr. Ravi Kant, Director of Metropolitan Education College, Dr. Randhava, HOD, Law Faculty, Ms. B.B.A, Faculty of Law, other faculty members, dear students. First of all, I must regret for the inconvenience caused to Honorable Mr. Justice Sinha while commuting to this college. It was about 50 kilometers from here, and on the way, the vehicle he was coming in broke down. It was really a test, rather trial of our strength, but our faculty who was escorting his lordship had managed another vehicle. So discomfort caused to Honorable Mr. Justice is really regrettable. Sir, Honorable Mr. Justice Naveen Sinha, I welcome you on behalf of the Sunshine and Educational Society, which runs this college besides many other institutions. And dear students, boys and girls, I welcome you to on behalf of the Law College DM. Today, our Honorable Chief Guest, Honorable Mr. Justice Sinha, he has contributed a lot to the cause of justice, and 2 very prominent judgments have been referred to by our director. Justice Sinha, when he was at the bar, he had practiced on almost all the sides of the laws, that is civil laws, criminal laws, revenue laws, service laws, and constitutional matters. But his contribution in the Supreme Court is more towards the criminal. Though, as referred to by our director, the significant contribution has been made by his lordship in civil causes also, in civil matters too. The first judgment I would like to refer relates to a judicial officer who was selected in Maharashtra Judicial Service. Mohammad Imran, he had cleared his judicial examination before he was implicated in a kidnapping case. There was no allegation against him of kidnapping or any other charge. The only charge was that he was an accomplice to the main accused who had kidnapped a girl, and the charge against the main accused was of the criminal assault too. The facts indicated that the main accused and Mr. Imran were going in two different shows, and the only charge against Mohammad Imran was that he had facilitated the offense of kidnapping. Anyway, the charges were framed against both the accused, and they had been acquitted. The main accused was relieved of both the charges, that is 363 and 376 under the old penal code. The police report was addressed to Mr. Mohammad Imran, and it said that he was involved in a case of moral turpitude. And same was the argument of the government of Maharashtra. They said that he was involved in an offense of moral turpitude. In the appeal preferred by the state of Maharashtra, appeal was preferred by Mohammad Imran himself, because the government had not given him the appointment. As I read, Honorable Mr. Justice Naveen Sinha comes from a noble descent. His grandfather was the first Advocate General of the state of B.B.A. And Justice Sinha's father has been an IAS officer who was posted as Additional Secretary in Government of India. So a person of his descent, noble descent, can do justice in such a case. Because the very term moral turpitude causes a great prejudice in the mind of everyone. But His Lordship, while writing the judgment on behalf of the bench, candidly observed that with the fact that Mohammad Imran had been acquitted, he was given a clean sheet that he was not at all involved in the offense. And the main accused too, when accused was relieved of the charge of 363 and 376 co. So where lies the offense of moral turpitude? Justice Sinha then granted relief to him. And friends, yesterday while we were interacting in another orientation interaction, I conveyed that you must always remember three words: just, fair, and reasonable. I believe you remember that. So, Honorable Mr. Justice Naveen Sinha, believing in these three words, these are the pillars. These words are the pillars of justice. He allowed the appeal of Mr. Imran and granted him the appointment as a civil judge unit division in the state of Maharashtra. It was indeed a real justice which has been granted to the appeal. Friends, I would like to refer one more judgment of criminal side, and it was a case of murder, of course, but the High Court had convicted the accused of culpable homicide. The culpable homicide, as you will read in while studying the criminal laws, is lesser kind of offense as compared to murder. Murder is punishable with life imprisonment or death, as the case may be. The facts were that there was a scuffle between two groups, and both had lost the FIRs. The FIR of the deceased, that is the person who was murdered, the FIR lodged by his family members, gave a cause of conviction to the accused. Siddharai Lakshman Chowgalia and others. But the government was not happy with the conviction under section 304, that is culpable homicide. It was pleaded on behalf of the government before Honorable Mr. Justice Sinha's bench that it was a clear-cut case of murder and the accused should have been given major punishment, either of death or of life imprisonment. The bench of the Honorable Supreme Court, presided by Honorable Mr. Justice Naveen Sinha, analyzed the facts of the case and came to the conclusion that the prosecution had concealed the fact about the accused's FIR. And not only that they had lost the FIR, narrating their story of the scuffle, but they also suffered injuries. And having regard to the injuries, the scuffle between the two varying groups, it was a case, clear-cut case of culpable homicide, not amounting to murder. Friends, one more case I would like to refer while highlighting the cause of justice. Honorable Mr. Justice Sinha has served while being in the Supreme Court, and it was a case of dying declaration. The accused had been convicted under section 302, that is murder, 302 IPC. The old act, of course, now Bharatiya Nyaya Sanhita has been enacted by the Parliament and it has been implemented with effect from 1st July. The accused who was convicted of murder and whose conviction had been upheld by the High Court came before the Supreme Court and preferred an appeal on the basis that there were three conflicting dying declarations. The bench of the Supreme Court analyzed all the three dying declarations. The first two, in fact, were termed by the court to be as self-serving dying declarations. That is, one of them was not signed by the doctor, and the other was made in presence of the relatives of the accused himself. So these two were said to be the self-serving dying declarations. Third was a perfect dying declaration. It was made in presence of a magistrate first class, and it was the dying declaration of the deceased, who was inflicted with injuries by the accused, and he has clearly named the accused appellant before the Supreme Court that he was the real murderer, and he was convicted. His conviction was upheld by the Supreme Court also. But what was the cause of justice? It was otherwise, it would have been a simple case. Before I before I conclude, I would like to refer to an anecdote of myself. I, as a magistrate, recorded the dying declaration of an injured person who had stated to me that he was murdered by the accused persons. He named them at a tube. But when the charge sheet was filed by the police, it was stated in the charge sheet that the murder had taken place on a highway, and this site of occurrence on highway was about half a kilometer away from the tube. I was summoned by the sessions judge, posted in the session judge of the same district, and then I was interrogated by both the parties. But since it had suited the accused himself, the accused was a real murderer, but he interrogated that with reference to my recording that the murder had been stated to have taken place at Cuba, which was half a kilometer away from the highway. It was on the basis of my statement that accused, though he was a real culprit. But you know, law is blind. There was a huge conflict between the two sites of occurrence, and on the basis of what was written by me in my recording of dying declaration, the accused was acquitted. Friends, the Honorable Mr. Justice served the cause in that case of dying declaration. What he did, that Lordship considered that the accused had already been in jail for 15 years. And in the jail manual, for your knowledge, many people may not be knowing this, that in the old Indian Penal Code, it was nowhere mentioned as to what is life imprisonment, meaning thereby the duration was not mentioned. By interpretation, the Honorable Supreme Court in many cases before the Bharatiya Nyaya Sanhita came into force had observed that life imprisonment in a particular case where brutality was too much would mean the remainder period of life. And it is on the basis of those observations of the Honorable Supreme Court that now in the Bharatiya Nyaya Sanhita itself such a duration has been mentioned. So this is the difference between the old law and new law. In Indian Penal Code it was nowhere mentioned. Coming back again to the case of dying declaration, Lordship decided that since the accused had already been in jail for 15 years, that is more than what was defined in the jail manual, life imprisonment in jail manual was meant only 14 years. So His Lordship directed in his judgment that the government must facilitate the accused to seek remission of his sentence. You will come to know under the constitutional law, the Honorable President of India and governors of all the states, they are entitled to grant remission to an accused. They can reduce or they can grant pardon to an accused person. Friends, with these words, I compliment Honorable Mr. Justice Sinha's contribution, particularly in criminal law, by deciding the cases having regard to all the facts, circumstances, and as such, he has served the real cause of justice. Thank you very much. God bless you.
Thank you so much, sir, for your inspirational words. We are very honored to have Honorable Mr. Justice Naveen Sinha, sir, as the chief guest today. To acquaint our audience with, His Lordship enrolled as an advocate in 1979 and practiced in the Patna High Court for 23 years on civil, constitutional, labor, service, commercial, company and criminal matters. In 2004, he was appointed as a permanent judge of the Patna High Court. His Lordship was then transferred to Chhattisgarh High Court in July 2014. He was also its acting Chief Justice and thereafter as Chief Justice till he sworn in as the Chief Justice of the Rajasthan High Court on May 14, 2016. He was elevated to the Supreme Court in February 2017 and held office till August 2021. I request His Lordship to address the gathering. Please, sir.
Justice Singh, office bearers of the institution of the dais, other teachers present here, and most importantly, my audience, the students. I use the word my audience because I am told that you are here for an orientation program and all of you are stepping into life now after school. I'll start with a joke, and the joke will explain that I will not say everything. I will leave some things to your imagination. Because when coming here and seeing all of you reminds me of when I entered law school in 1976. All thoughts were coming back and all kinds of images and feelings were surfacing. While I was in Chhattisgarh as the Chief Justice, I was the Chancellor of the Hidayatullah National Law University. So I was invited to talk to the students, to deliver a talk. In my opening lines, I said, I don't know whether to pity you people or to envy you people. But I think it is safer for me standing here to say, I envy you people. Because if I say I pity you people, the next question one of you is going to ask me is, how the hell did you become a Chief Justice? So what I was basically trying to convey to you was that things were a lot different when I joined law and when you have stepped into law. It's a long journey from 1976 down to 2024. A lot of changes have taken place. A lot of developments in law. A lot of developments in society. A lot of developments in human behavior. Human desires. Everything is coming in. So when you step into a new life, into a 5-year law course, the first thing I want to tell you is, and this I am talking from experience. I think somebody didn't like the idea of my using the word experience. Anyway, what I want to tell you is that when you step into life, it's a very long journey. You will change tracks, you will make mistakes, you will learn. And destiny plays a very, very strong role in shaping your life and your career. That does not mean that because the astrologer saw your hand and told you you'll become a very good lawyer, that you sit back and say, well, my destiny says I'll become a lawyer and I'll be a famous lawyer. No success is possible without hard work. But in spite of hard work, destiny plays a very, very important role in how we shape up our lives. I think the most important thing is, first, to always keep in mind the values, morals and principles that your parents gave you and what your school gave you. That shapes your personality. There is an old saying that you can fool some people sometime, you can't fool all the people all the time. In other words, you must always be honest to yourself. Never try to pretend something that you are not. Never try to run away from responsibility. Now coming to the field of law, a lot was said by the earlier speakers. Before I come down to certain more issues. One, Google was referred to. My request to you will be, of course, that was in a different context, to look up my judgments. But I thought I will tell you people that since you are students, I'm talking on a totally different perspective from what was mentioned about my judgments being on Google and finding out the judgment, kind of judgments. Google is good for information. Information to make you think, to make you do more research. But don't be guided by Google, that Google said go left, so I must go left. I'm quite sure you must have, all of you must be aware, because it was in the electronic media reported a lot. Somewhere down in the south, Karnataka, somewhere in the night, 3 friends were driving and they were following Google on the map and they ended up in the river. So therefore, yes, Google is all right to first get a hang of what the issue is, what the topics are, what are the different views, but not the conclusions. In fact, courts have also held that Google is good for research, but not for deciding cases. A lot was said about some judgments delivered by me, but obviously everybody doesn't think the same. In one of the judgments that I delivered with regard to the Employees Provident Fund, my daughter rang me about 11:30 in the night, the day I delivered the judgment. I was the presiding judge and the judgment was authored by me. So as a father, I naturally got worried. And I tried to inquire her well-being, etc. She said, don't ask me stupid questions. What have you done today? So I said, what have I done today? The next thing she said is, you think you are very intelligent. Who made you a judge? So I said, what has happened? She said, you have said that we'll get money when we are old. We want the money now. What kind of judgment is this? So that was related to some deductions, etc. from the salary, which would come back as pension later on. And justicing my father was not an IAS. My father was a technocrat, he was an engineer, and it was an unheard of thing in the 70s that an engineer would become a joint secretary and go on to become an additional secretary. Today, of course, it's been followed off and on, but at that time it was something unthinkable. Now when you study law, you were just told about summary. I think that is the most important thing you must understand. Two things. Number one, when you are studying law, keep your mind open. Let your thinking wander. The conclusion will come out gradually over time. Don't jump to conclusions. Human behavior is very unpredictable. No two people will behave the same way, in the same manner, in the same situation. The changes that you see in the criminal law coming in, the 3 laws which have come, they are again the outcome of the changes taking place in society, the changes that took place in the nature of crimes, and most importantly, when you start studying them, you will find a lot of them are the outcome of judicial pronouncements. The courts led the way that these changes are required, or they interpreted it in a manner necessitating that the law be amended to bring it more in conformity with what is required. But as far as you are concerned, I will only caution for one thing, that if you want to enter the profession of law, and of course your options will be very wide open. You are doing, I believe you are doing a 5-year law course in LLB and B.B.A. All of you may not necessarily enter the legal profession. Some of you may chart a different path. The options in the legal profession are also very different now compared to what it was when I finished law school. Many of you can join the corporate world, law firms, legal advisors. Some of you may go into the profession. But wherever you are, if you are dealing with the legal aspect, 2 things are very important, as was pointed out by one of the speakers. Brevity. See, the more you speak, the more you write, you create a cobweb for yourself. When you are thinking, your thoughts will be all jumbled up. But you have to sift them. When you start sifting them, you will have to make sure that there is coordination between what you are thinking and what you are writing, or between what you are thinking and what you are speaking. because jumbled up thoughts in the mind will result in a situation that you may have the nicest thoughts in your head, but because of the inability to communicate, you don't put it down properly, or you miss out the important aspects in the writing or in the speech. And as was pointed out to you, that you will get very short time before the judge, so you have to be very sure what is relevant, what is not relevant, what needs to be highlighted, what does not need to be highlighted. And of course, when you come to the court, you will find, of course I can talk only about the court, the other aspects I don't know. Because after I finished law school, I took a job, worked for 7 days and realized that I was not cut out to be I was not cut out by nature to do a job, and I came back to the legal profession. So therefore, when you come to the legal profession, as I said, be honest to yourself, do your homework properly, and yes, most important, because the sky is the limit in the legal profession, meaning thereby that success cannot elude a person who works hard. Of course, there is a saying that there's nothing like a successful lawyer and there's nothing worse than an unsuccessful lawyer. Those are good metaphors, but in real life, what my experience tells me is that any lawyer who works hard, plays the long innings, for him or her, the sky is the limit. One case will not decide your future. When you start studying law, you read some books, read about some great lawyers and judges, you will find that in the beginning they had no work. Till one day Lady Luck finally smiled on them. So you don't have to worry about those things. What is more important is your reputation. When I say your reputation, what I mean is that you must be honest to yourself. You have a duty to your client, no doubt about it. But you also have a duty to the court. So you have to strike a balance between the two, which will mean, and sorry, not between the two only, and you are the fulcrum, because it's your career. You are the one who's addressing the court. So when you're standing in a court, what is most important is to generate an image, convey a character where the judge says to himself or to herself that yes, I know this lawyer does not mislead, this lawyer does not make false statements, I can rely on what this lawyer says. That makes your job much easier. So therefore, once you'll have to make up your mind whether you want to come into the legal profession or you want to join the corporate world. Whatever I am communicating with you is exclusively for the legal profession. As far as the corporate world is concerned, it's a different ball game altogether. As I said, I'm not competent to say anything on that. And one more thing from my own example. Never be afraid to say, I don't know. I'll give you 2 examples. Because the moment you have the courage to acknowledge your own limitations, new boundaries will open for you. My acting Chief Justice in Patna, a lot has been said about me about criminal law, and that I delivered a lot of judgments in criminal law. Now I will leave it for you to think. I had an acting Chief Justice in my High Court in Patna, a local judge, who made me sit on the criminal bench to preside over the criminal bench. So I told him, what have you done? I don't know anything, because I had no practice in criminal law at all. So he said, कि कल कहीं जाओगे चीफ जस्टिस बन के तो क्या बोलोगे कि नहीं आता है सीखो. So I learned criminal law sitting on the bench as a judge 6 years after I was elevated as a High Court judge. The message I want to convey to you is, it is never too late to learn. It is never too late to learn. One more thing, this I must tell you before I give you the example, that wherever you will settle down, wherever you will start your practice, every state, the litigation pattern in every state is greatly conditioned by the socio-economic conditions of the state. So having practiced in Patna High Court, the socio-economic conditions of Patna, of Bihar, did not give me the opportunity to delve into or learn much on commercial laws. So when I was transferred to Chhattisgarh, Chhattisgarh has a lot of industries. I was the acting Chief Justice. Everybody knew I was going to take over as the Chief Justice. Of course, I will not take names. One day I entered the courtroom and I saw a very senior commercial lawyer of national repute from the Supreme Court in the courtroom. My blood froze. I said, what is he doing here? He started arguing. I couldn't follow anything. And mind you, this is 10 years after my elevation. I couldn't follow anything. 5 minutes, I did not stop him. Everything was going over my head. And and in those 5 minutes, all kinds of thoughts came to me. What will he argue? What will I understand? What will I write? The Supreme Court will probably stricture me. I will not even become a Chief Justice. Then after 5 minutes, I stopped him. And I said, Mr. So-and-so, 23 years as a lawyer, 10 years as a judge, I have not done a single case like this. Teach me. The rest is history. I don't difficulty about it. So the message I want to give you is, never be afraid to say that I don't know. Tell me. The day a lawyer says, yes, I know everything, let me tell you, the lawyer is doomed that day. As much as a judge who says, don't try to teach me the law, I know the law. Therefore, I wish all of you the best, and work hard, but at the same time enjoy yourself, because this is a phase of your life which will never come back again. But today, the competition is much more. You know, when I went to law, the Delhi Law Faculty to take admission, today things are very different. There is a competitive exam. We just walked in, there was nobody taking admission. I still remember, as I said, thoughts were coming back. The admission window was empty. I just walked in. But today times are different. You will face a lot of competition. You have to perform. You will have to do a lot of reading. And again, I'll emphasize, please develop your writing and communication skills for this profession. Whether it is Hindi, whether it is English, I'm not going to harp much on that. Whatever it is, whatever language you are comfortable in, develop your skills there. Learn to say as much as possible in as few words as possible. I think I don't have anything much to say now. If anybody wants to ask me any question, I reserve the right to give answers or to keep quiet. But if anybody has any student has any questions to ask, I will only be too happy to answer. And don't worry, you don't have to be scared of anything. I'm a retired judge. All right, so I take it that nobody wants to ask any questions. Thank you. Yes. Yes.
Good afternoon, sir. Sir, law is very emerging in today's time. My question is, after looking all the scenario in law field, we can see today also first generation lawyers are still struggling. So what is your view on this?
Very good question. That question is more in the background of what was just said about me. I'll answer it. I'll answer it very frankly. Please sit down. Yes, there is a general impression that first generation lawyers have a very difficult time. And lawyers with a background or family members in the profession have certain advantages. I will say that is both true and untrue. When I say true, generally speaking, I would say 95%. The rise has been meteoric, but the fall has been sudden also. As you grow in this profession or as you study and you interact with people in the legal field, I don't want to say anything more on this, you will acquire knowledge for yourself. Conversely, there have been cases where a first generation lawyer's rise has been meteoric because of hard work. My grandfather was a leading criminal lawyer. He was the first Advocate General of Bihar, yes. But mark my words, he expired in 1959, 3 years after I was born. My father was the eldest, the second brother became a lawyer. And then he became a High Court judge, and I entered the profession in 80, he retired in 90. I was elevated as a High Court judge in 2004. But let me tell you one thing very clearly, not a single client came to me in the name of my grandfather or in the name of my uncle. Yes, it's a different matter that once you start interacting with the client, then especially if they were of the elder generation or much elder to me, they would say, oh, you are so-and-so's grandson. But mind you, saying that I am so-and-so's grandson may have brought me 2 more briefs. But if I did not perform in those 2 briefs, it may have got me another 3 briefs. But that would have been the end. So after those 2 briefs came, I had to prove myself. So therefore it is a myth that people who belong to the legal, who have a legal background have an advantage and ride rough over others. No, it gives you an initial advantage. There are innumerable instances, to my knowledge. There is an old saying in Hindi, बड़े पेड़ के छाया में छोटा पेड़ कभी बड़ा नहीं होगा. So there are some exceptions where big lawyers, their son and daughters became good lawyers. But when you look around, you will find that they are very few. So it ultimately boils down to your hard work, to your honesty, to your belief in yourself, and your belief. You see, what will happen if you go trekking and somebody tells you that is a long route, let's take a shortcut. Now you understand what I am saying by shortcut. Shortcuts can be misleading. So you must always play safe, play the long game, and success cannot elude. Anybody else? That was a good question. Sorry, yes, please.
Very good afternoon, sir. My name is Shaurya. I would like to ask, sir, is marketing ourselves as a lawyer is important in the law field?
Better. You see, what is happening today is, I want to clarify, I may be conservative in my thinking. Outside the courtroom, I was very conservative. Inside the courtroom, I was very liberal. Today, there is a lot of misconception about the legal profession that lawyers make a lot of money. A lot of youngsters are getting attracted by it, which leads to lack of proper training. When the lack of proper training comes in, then the question of marketing comes in. I very firmly believe that a lawyer can never market himself. All of you are familiar with the good old English proverb, an empty vessel makes more noise. So there will be a lawyer whose hard work will speak, and there will be a lawyer who will be beating the drum to attract attention that look at me, I am also here. So let your work make the noise. Don't think in terms of marketing yourself as a lawyer. I don't believe in it. I know what is happening today, and I don't want to talk about it because it may give you the wrong impressions. The quicker the rise, the harder the fall. Keep that in mind. Any more questions? Yes, I'm glad people are asking questions. Your mind at this age should be inquisitive. The lady raised her hand, let the lady speak first, I'll come back to you. I'll come back to you after that.
Good afternoon, sir. My name is Naina Sharma, and sir, I wanted to ask, same thing is here also, that I am the first generation lawyer. Sir, I wanted to ask if I am very clear about judiciary, so what tips and the things I can do at this year to enhance it and to clear that exam?
I'm very glad you asked that question. I forgot to mention when I said that you have the corporate world and the legal profession, etc. As far as you have a very good option in judicial service now, because today the service conditions are much better, far, far better than what it used to be. It gives you a kind of stability, it gives you recognition, it gives you a social status, and more important than anything else, it gives you satisfaction. Now the question that you asked, what can you do at this stage? I am reminded of an interview I was taking for judicial officers. And I can recollect two girls at this stage in Bihar when I was taking this interview. I think that will answer your question completely, how you are supposed to prepare yourself. There was this young girl whom I asked, this was somewhere way back in 2010 or 11. I asked this, I was heading the interview board and I asked this young girl the question. She had qualified in the written examination and I said, give me one good reason why I should select you. Because if I select you, we will spend a lot of money in training you. And please don't get my questions wrong, I am not a male chauvinist, but I am just giving you an example of the question, in trying to answer the question you asked. So I said that I'll spend a lot of money on you on training. And tomorrow you become a judicial officer, you start working. Number one, your husband will also be earning, so you will be supplementing the family income. Then either your parents may get you married tomorrow, and you say that, well, I can't afford to continue here, I have to go with my husband, and you leave. So in both the situations, I think it is a male person who needs the job more to run a family. And what was that young girl's answer? She said, sir, I am not taking away anybody's job, the Constitution guarantees me equality. Needless to say, she was selected. There was this another young woman. I put to her that you want to join the judicial service in Bihar. you will get posted to a place where perhaps there will be no proper electricity. I gave her the example of a particular district which was very crime prone, and I said, you are unmarried, you're living alone, and tomorrow you have to hear a bail application of a known criminal, and in the night he calls up and he says that, madam, I know everything about you, you live alone. I only wanted to tell you that my bail is coming up before you tomorrow, and if you don't allow it, things can be bad for you. How will you react? She kept quiet. For full 5 minutes she kept quiet. And we waited for an answer. The answer she gave was, if I can't protect myself, what justice will I give to others? So she was selected again. Now these examples are the candidates who were being honest to themselves. These candidates were keeping on a very high pedestal the values, morals and principles that their parents and their school taught them. So at this stage, you don't need to do anything more. Be confident, study hard, work hard, don't take shortcuts. There's nothing more I can say at this stage. Yes?
So good afternoon, my name is Yasham Sharma. So my question to you is that right now all the legal fraternities, especially the courts in our country, they are being the torch bearer for the rights of the underprivileged. There might be some chances while delivering the justice that there are differences of opinion between the courts in itself on the same cases might be.
Between the court and?
Between the court cases in the same case only.
Okay.
Differences of opinions. So sir, what are your views on that? If you can shed some light on this.
Very interesting question. When I became a judge, somebody gave me a book to read. The author was a judge of the US Supreme Court called Robert Fletcher. The title of the book was How Judges Think. And when I started reading the book, I was lucky. I got it when immediately after my elevation, somebody gave it to me to read it. When I started reading that book, my reaction was, judges all over the world seem to be having the same problems. What I'm trying to say is that how a judge thinks is greatly conditioned. The judge is not aware of it. It's only when the thinking starts, the introspection starts, then these thoughts come to you. A lot of my brother judges may not agree with me. How a judge will think depends a lot on the kind of family that person was born in, number one, the kind of education the individual had, the kind of friends he had, the social environment in which he grew up. These are the things which condition the thinking of the mind of the judge and try to control it. But the real duty of a judge is to be objective, and that is why in the Judicial Academy I used to use this phrase that, and I borrowed it from the book. When you put on your gown, it is like putting on a new skin. So you are supposed to shed your own skin, put on a new skin, and then think. That is where the problem lies. And for that, I'll give you an example. In Chhattisgarh, there was this matrimonial matter where the husband and the wife both were teachers before they got married. When they got married, the husband told the wife that you take a transfer here, both of us will live together here. So she tried, she didn't succeed. When she didn't succeed, she told the husband that, look, why don't you take a transfer? Anyway, my salary is higher than yours. So the husband said that, no, you resign and come. She said, I will not resign. So that led to a matrimonial dispute. What did the judge say? I didn't take even half a second to set aside that judgment. The judge said, well, we are a traditional Hindu society that it's the duty of the wife to follow the husband. So refusing to go and live with the husband is cruelty, divorce granted. Yes, those are very serious problems. that happens. I don't have to tell you, you are reading in papers every day that judicial pronouncements, a lot of conflict is coming in. And I hope that one day we will reach some kind of uniformity. I'm quite sure you are aware of several instances, because there are several instances which have come in the past in the newspapers also, which anybody with a legal background will raise his eyebrows. Yes, any more questions? Yes?
प्रणाम सर, मेरा नाम प्रणववीर सिंह है और सब्जेक्ट से रिलेटेड ही मैं आपसे क्वेश्चन पूछना चाहूँगा। एक केस है रोमेश थापर और स्टेट ऑफ मद्रास। उसमें क्या किया था कि रोमेश थापर ने कांग्रेस के खिलाफ कुछ क्रिटिक्स जारी कर दिए थे, तो उसे मद्रास मेंटेनेंस ऑफ पब्लिक ऑर्डर एक्ट जो सेक्शन 9 का कहता है, उस जनरल को ही बैन कर दिया था। तो सर मेरा क्वेश्चन आपसे ये है कि अगर उस जजमेंट में अगर आप केस डिसाइड करते तो मतलब कॉन्स्टिट्यूशन सुप्रीम है या फिर जो स्टेट एक्ट को सुप्रीम, क्योंकि आर्टिकल 19 ऑफ द कॉन्स्टिट्यूशन ये कहता है कि हमें राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन है, और जिसका यूज रोमेश थापर ने किया, और आर्टिकल 32 भी इस कॉन्स्टिट्यूशन में आया था। तो सर आपका क्या कहना है इस जजमेंट के बारे में?
इसका जवाब बहुत सिंपल है। जवाब बहुत सिंपल है। मेरी आज़ादी खत्म हो जाती है जहां आपका नाम शुरू होता है। उसका मतलब समझे? नहीं समझे? हम तभी तक बोल सकते हैं जब हम किसी दूसरे को बेवजह बिना कारण के उसको क्षति नहीं पहुंचा रहे। मेरे बोलने मेरी आज़ादी की एक सीमा है, और उस सीमा को बरकरार रखने के लिए हमको दूसरे की आज़ादी की सीमा को भी पहचानना पड़ेगा। क्योंकि आप दूसरे के घर में घुसेंगे रात में तो लाठी से तो मारेगा ही आपको। आई होप आंसर क्लियर था। नहीं, जो केस के बारे में आप पूछ रहे हैं उसका फैक्ट्स हम नहीं जानते हैं, इसलिए हम जनरलाइज करके आपने जो पूछा उसका ठीक है, हम दूसरे तरह से भी कह देते हैं कि नॉर्मली स्पीकिंग सेंट्रल कॉन्स्टिट्यूशन सुप्रीम रहेगा। कोई भी स्टेट कॉन्स्टिट्यूशन के विरुद्ध लॉ नहीं बना सकता है। सेंटर ही नहीं बना सकता है तो स्टेट क्या बनाएगा? लेकिन आपका जो सवाल था वो ज्यादा उस क्षेत्र में जा रहा है, मेरी आज़ादी खत्म हो जाती है जहां आपका नाम शुरू होता है। Thank you. It's very nice speaking to you. And the reason I asked you to ask questions is that once you become a judge, having been a judge for nearly 17.5 years, a monologue like a college professor, I couldn't have gone very far. But when there is a dialogue and my brain starts working, then I can probably do better. Thank you very much.
Thank you so much, sir, for your inspirational words. We are very honored, Your Lordship, could join us here today. I request our Director General, Honorable Justice Bhavar Singh, sir, to felicitate our Chief Guest with token of appreciation and gratitude. Thank you, sir. With this, we move to the end of the event. I request HOD Law School DME, Professor Randhawa ma'am, to conclude the event by delivering the vote of thanks.
Thank you, Nasa. Our worthy chief guest for the day, Honorable Justice Naveen Sinha, Honorable Justice Bhavar Singh, sir, Director General DME, Professor Ramikant Swami, Director DME, Ms. B.B.A. Daily, Convener for this orientation program, faculty members, and my dear students. So today, again, we are standing at a platform where you will be starting your new journey. And this journey will be a transformative journey. Transformative in the sense that it will going to shape your future. Not only your professional future, but also your professional growth, your understanding about the world. And as you are stepping into the new chapter of your life, you are joining a tradition of excellence, dedication, unwavering commitment to justice and integrity. And this road ahead will be challenging, yet incredibly rewarding. And you will delve into the complexities of law, explore its nuances, and confront ethical dilemmas that demand critical thinking and compassionate reasoning. DME Law School, we are focused about your comprehensive, holistic development. And we are having so many opportunities in the form of various cells that are working at the institution level as well as at the departmental level. I encourage you to join more cells. You have 24 hours in your pocket, right? And utilize those 24 hours as much as you can. So I encourage you to actively participate in all the vibrant communities of DME Law School. And my heartfelt congratulations to you on reaching this significant milestone. You are about to embark the journey that will demand your utmost dedication, your passion, embrace the challenges, cherish the success, always remain true to the principles of justice and integrity, and define our profession. Right? And be truthful to yourself, be honest. As it is said that honesty is the best policy. But I believe that honesty is not the best policy. We always heard that honesty is the best policy. Is there anything else which can be the best policy? How many of you are approving this statement? Honesty is not the best policy. So I believe honesty is the only policy. It is not just the best policy, it is the only policy by which you can chase the success. Be truthful, be honest to yourself. And now it is my profound privilege and honor to deliver the vote of thanks for this orientation program on behalf of DME Law School. First of all, I would like to express our heartfelt gratitude to our esteemed chief guest, Honorable Mr. Justice Naveen Sinha, sir. Your insights and advice have undoubtedly inspired and motivated our students, and your willingness to share your knowledge and experiences is invaluable, and we are truly grateful for your presence, sir. Thank you very much for taking out your precious time to address our My sincere thanks to our chairman, sir, Shri Vipin Sani, our vice chairman, sir, Mr. Aman Sani, for their continuous support in all our endeavors. My sincere thanks to our Director General, sir, Honorable Mr. Justice Bhavar Singh, for always being there as a mentor and guide, showering his kind blessings upon her, sir. We look forward to your continuous kind support and guidance in all our future units. And I'm also thankful to our Director, sir, Professor Dr. Ravikant Swami, for his immense support and very invaluable inputs from time to time. And a special note of thanks to all the volunteers, student volunteers, and the entire orientation team who have worked tirelessly to make this program a grand success. My sincere thanks to our dedicated administrative and support staff. Their hard work behind the scenes has been instrumental in ensuring everything runs smoothly. Thank you once again to everyone who has contributed to the success of this orientation program, and we look forward to seeing our new students grow and thrive in their time here at DME, and we are excited to see the incredible contributions you will make both within these walls and in broader world as to the new chapter which would be filled with learning, growth and achievement. Thank you so much.
Thank you, ma'am. I humbly request everyone to stand up for the national anthem.
Janaka